Just on the sharing abhorrent material criminal code, I asked questions similarly in the communications portfolio earlier today. Just on technical drafting issues, is it your view that the bill has banned sadomasochism websites because of your definition of torture to not necessarily be just non-consensual?
The effect of the bill is not necessarily to ban websites per se, but to require the companies to take down material. So yes, it fit the definition of torture in that bill.
Is it the intention to prevent the depiction or streaming of violent, controlling behaviour when it's consensual?
So the bill was clearly a response to the matters that occurred in Christchurch and subsequently, but is intended to capture any extreme violent material that's streamed or recorded and is available on online platforms.
There's an express definition of torture, I think.
There is a definition of torture, but it doesn't hinge on it being non-consensual. So I'm just wondering whether you believe...
Yes, and we did, I think in the definitions, try to limit the complexity because obviously it involves judgments by online platforms that can result in criminal liability. So matters where they're required to make judgments that are complex, we tried to avoid. We have included it, obviously, because we had to for the definition of rape, but torture, the decision was that if it fitted that definition of torture, it will need to be taken down.
The risk is, of course, that, one, I think on the face of it, you may have banned essentially consensual torture being depicted, and even if it's not clear, ISPs will take the risk-averse approach of removing that content anyway because it's not clear that S&M sites would be able to continue under this legislation.
It is the case that online platforms, if the material is accessible in Australia and fits that definition of torture, will need to remove it once they become aware of it and remove it expeditiously.
Okay, well, the S&M community might not be too happy about that. Can I go to the other element of drafting? It doesn't relate to broadcasters. Can you please outline the motivation for just focusing on ISPs and content providers?
There's broadcasting services legislation that exists. This was particularly focused on internet service providers, social media services and other internet services.
So, but a screen is a screen and eyeballs are eyeballs, and if you're viewing abhorrent violent material, it doesn't matter whether it's broadcast or on an ISP.
I couldn't comment about the broadcasting regulation because that's administered by Department of Communications, so it may be that you would want to ask them about the obligations.
But your legislation could very well,
broadcasters.
you would have the jurisdiction for your legislation to cover broadcasters.
What I couldn't comment on is
code.
whether they're already subject to such restrictions under other legislation, so I'm not able to answer that, but Department of Communications.
But you could confirm that whatever is covered in broadcasting legislation, it is not defined in the same way. You've come up with a new definition of abhorrent violent material and content, and you've come up with specific penalties. It would be completely improbable that the exact same language and penalties exist in broadcasting legislation.
Sorry, did you have a question, Senator?
So isn't it the case that the penalties for any depiction of abhorrent violent material by broadcasters is not the same as the penalties under this new bill?
I couldn't comment on that.
Could you advise what the penalties are under your criminal code amendments vis-a-vis the penalties
We can advise,
under,
yes, I can advise on the penalties under this legislation.
but as they compare to penalties for broadcasters?
No, Senator.
You don't think it's relevant for
No,
the
she said
Attorney
she
General's
can't-
Department?
She hasn't got the details of the broadcasters, I think you'd
No,
say.
but
That's right.
when you're introducing legislation to penalise a particular activity, surely it is within the Attorney General's Department's responsibility to know how that penalty compares to the exact same behaviour by a broadcaster doing the exact same thing.
I think there is just an existing quite comprehensive regulatory scheme for broadcasting services.
That doesn't involve
administered by another
predominantly civil
portfolio.
penalties rather than criminal penalties.
So government ultimately made the decision
The
that it
policy
was
focus of
appropriate
this
to
act,
target.
Senator, was about what happened post-Christchurch during the course of the activity in Christchurch. That was the focus of this act. Ms Chigi has alluded to the fact that we would take on notice the comparison and contrast with the broadcasting providers. In that context, we were addressing a specific concern with social media companies. And as Ms Chigi alluded to, it may be in the future, a government would have to look at the issue of comparison.
It's just a concern that this was rushed and the production of legislation that doesn't cover what it potentially should cover is a concern, and we perhaps shouldn't have rushed it as much.
That's
I don't know-
entirely your opinion, Senator Spender.
And Senator Spender, your time is long.
I don't know whether it's an opinion that it was rushed, given the fact that the bill was introduced and passed within minutes.
Senator Spender, you're
No,
perfectly entitled to your opinion on this. I would like
Yes,
to
but
disagree.
not in